Hi there, Tim Santoni with Santoni Investigations, and welcome to the Ask a PI show. We will be answering those questions you've always wanted to know but didn't know who to ask. We're going to give you an insight into the private investigation industry and everything that surrounds it, from the Hollywood image to in-the-street stories to experts and technology. Our goal is to get feedback and input from you so that we can provide more value to our viewers. Feel free to tweet in questions using the hashtag AskAPIShow, and we'll get your question answered on the next show. So, what is pretexting? This is a term that's now thought of as a naughty word, right? Pretexting is bad. And I think this stems from the HP scandal, where the board members were conducting investigations on other board members and using investigators to obtain protected information, namely phone records, financial data, bank records, social security numbers, and using that information as intelligence and information to gain power, knowledge, or authority, or to persuade folks. Pretexting is not necessarily a bad or dirty word. Pretexting just really means that you're using a story or information to obtain information you may not be able to obtain if you were being clear and transparent as to who you are. So creating a great story around who you are, why you need the information, to let that person you're speaking with or that business let their guard down and share information openly. It is against the law to use pretexting to obtain socials, dates of birth, driver's license number, bank accounts, phone records. That is totally against the law, and if you look up the term, that's what you're going to see come out first. Pretexting and investigation, specifically in the IP area, there's case law that supports the fact that conducting pretexting calls or calls to another business in a B2B context about products or services you may want to acquire is not pretexting. In the dirty word version. It is pretexting in the sense you're using a story or a ruse to approach that person and obtain information that you could use. But that information would be available to any other business or individual that would approach this person or business in a similar context. And there's even information to suggest that pretexting in the context of IP and trademark matters, when you're contacting litigated parties, is not deemed ex parte contact because of the fact that you're doing it in a way that a true consumer would, and you're not trying to obtain information that a consumer wouldn't, any ordinary consumer would otherwise be asking for. It's the same situation. Again, there's case law in different circuit courts that support that. Again, and pretexting is not a dirty word when it comes to IP and investigations. It is a dirty word when it comes to obtaining information that you should not have your hands on. That's the story when it comes to pretexting. Thanks. Thanks for checking out the Ask a PI show. We encourage you to tweet in your questions using the hashtag AskAPI at TJ Santoni, or you can send it via email. We'll link that up in the description below. We look forward to answering your questions on the next show. Thanks.